Hi, everybody. We just launched our broadcast. We're going to give everybody a minute or two to jump in so we can let all the registered people get online. That takes us just a minute or two, so just stand by for a moment. All right, it looks like it's kind of leveled out. I took a moment to close my door. I do have 2 dogs in the office today. Welcome everybody. This is session number 7, I think, of our pandemic recovery series. And today we've got Richard Cheng with DLA Piper to go over the legal aspects of our pandemic recovery. And so I'm going to just do introductions real quick. My name is Amy Knight. I am with Knight CPA Group, CPA firm here in Austin, Texas, serving nationally home care, hospice, nursing home providers, and that's all that we do. And then Richard, can you advance to the next slide, please?
Sure.
Richard's in charge of the slides. This is Richard's background, and I'll let him do his introduction once I turn it over to him. So what do we got next? And all right, we got a disclaimer saying, you know, by joining this webinar, you have not engaged any of us in formal services, okay?
Okay, I'm going to slip over this and just go because the presentation overview, I amended it.
Okay.
So this actually is the beginning of the presentation.
Oh, okay. So we don't have introductions for the rest of the sessions. No. Okay. So I'll just turn it over to Richard.
Well, good afternoon, everybody. I think it's just 2 minutes after the 12 o'clock hour. I'm glad everybody is able to make this webinar. I have the privilege to speak to all of you, and I'm happy to be here. You'll have me me exclusively for the entire webinar. I hope you walk away with something under your tool belt, and hopefully you can gain some perspective on the legal aspects of your operations, the market within the home healthcare industry, and what's going on from a compliance standpoint. I'd like to emphasize for a second that the topics we're going to cover, it's pretty vast and it's pretty diverse in nature. And so really, it's really hard to really dig deep into one particular area because the topics are so diverse. And the objective for today is really to allow you as the listeners or the audience to issue spot along the way. It's not to make you experts in any one area. It's certainly not tailored for any one particular situation. I can't emphasize enough that legal issues, especially with something as highly regulated as healthcare fraud or privacy issues or employment issues, it's very factually based. And why that's important is because within the confines of the law, there are a lot of exceptions and there are a lot of different details that trigger certain aspects of the law, and then there's other certain factual scenarios that doesn't. What I'm trying to say is, even though I'm presenting general concepts of the law, it may or may not apply to you given your situation. And given the scope of this presentation, while I encourage you to ask questions, absolutely ask questions, we just simply don't have the ability to answer everyone's factual specific question and break down an analysis. I don't think that's the purpose of this presentation. So take it in, really absorb it, but really just understand this is to help you issue spot, and hopefully it'll give you some tools on helping you operate in a more compliant and effective manner. As for myself, my name is Richard Cheng. I'm a healthcare attorney that specializes in representing healthcare providers. I've been in the healthcare space for, well, about 20 years now, really 15 as an attorney, and then I started off my career in 1999 as an occupational therapist in skilled nursing facilities and home healthcare agencies. So I've been in the post-acute care space for well over 20 years now. It's been a great career. The firm I'm with is a global firm, but my practice is specifically in healthcare regulatory work, transactions, and also advising home healthcare agencies in labor employment issues. But it's very compliance and regulatory based. But without any more delay, let's just jump right into it. Okay. Let's start off talking about what's really happened. Since March, first or second week of March, we've all experienced a lot of changes in our personal lives, in our careers, and obviously your businesses. In response to COVID-19, the federal government really passed three big pieces of legislation, and it started in early March and it went through late March. And of course, the effects of those three pieces of legislation still is very much in place. I have it written down. I don't have to read every single word for you, but just to give you some background, the Coronavirus Preparedness and Response Supplemental Appropriations Act was passed in early March. As you can see, $8.3 billion in emergency funding for agencies was designed to specifically address coronavirus outbreak. About a vast majority of that went to HHS, Health and Human Services. 3.4 billion of that went to the Public Health and Social Services Emergency Fund to do research and vaccines. You don't really hear about that piece as much, just because it doesn't impact you as directly as home healthcare providers and as healthcare providers in general. However, the two latter pieces of legislation does have more impact. The first one being the Family First Coronavirus Response Act. That's really going to affect your staffing and your workforce. And we'll talk about that a little bit later in the presentation. But the big one that you've probably heard more about and that you've actually seen a more direct impact on your operations and your business is the CARES Act. The CARES Act passed on March 27th of 2020 of this year, and it's by far the largest major piece of legislation that was passed to address COVID-19. I believe it allocated about $4 trillion in funding. Vastly surpassing any other piece of legislation I've ever seen. And if I have that $4 trillion incorrect, don't quote me on that. I believe it was 3.9 or 4. And it was really broken down to two different divisions: a mandatory bucket and a discretionary spending bucket. And more or less, as some of you may have experienced, in around second week of April, between the 14th and 18th of April, you probably got some funding directly in your operations account. Well, that's the bucket it came from. It came from the CARES Act bucket. But what else did it do? It encouraged the use of telehealth and home health care, subject to reimbursement limitations. I believe about 2 or 3 weeks ago, we talked specifically about that. While telehealth did open up more in home health care, the reimbursement aspect of telehealth was still somewhat limited, and it continues to be limited. What it also did is suspended about 2% of Medicare sequestration, and it effectively increased your reimbursement rates for about 8 months for the rest of the year and to potentially even next year. It creates a $100 billion healthcare fund for recovering COVID-19 costs and increased Medicare reimbursement for providers for taking care of COVID-19 patients. There's some other big pieces as well. The one that comes to my mind the most is the lost revenues, public health bucket of money. That's about $100 billion in funding, where providers can actually show lost revenue to justify getting additional funding. So let's talk directly about privacy and cybersecurity issues. So this is really issue number one. So we're going to break this presentation down into privacy and security. That's really the topic number one. Then we're going to talk about healthcare fraud and abuse. We'll transition into some of the contractual commercial litigation concerns as it relates to COVID-19, and we'll wrap it up with a lot of the stuff that's going on with the FFCRA and some of the more recent litigation results that actually more or less change the landscape of FFCRA, and I'll explain why. So this is essentially topic number one. Privacy and security has always been an issue in healthcare. Home health, hospice providers are by far no exception. Why? Because you're holding PHI, you're holding sensitive information, you're exchanging information with vendors, you're receiving information from different parties, of course, those third-party payers. So there's a lot of exchange of PHI, protected health information. And so during even pre-COVID-19, privacy and cybersecurity were already issues. But what did COVID-19 really do? It created a situation where a lot of people were working from home. People that were once traditionally working in the office, and I'm not talking about your field staff, your nurse that's out in the patient's home. I'm talking about the records person or the accounting person in your office. And granted, the people who are on this phone call that's listening to me, different businesses will have different types of employees, and you guys vary in size. So the situation with COVID-19, it forced the migration of the workforce from the office to the home. And when you're working from home, it doesn't provide as much of a structured environment compared to a typical business environment or typical office environment. So you're adapting. And through that adaptation, you're having to take potentially computers home, you're sending a lot more information to yourself. You see employees or staff sending information, potentially even sending it to their personal accounts. And that does create some cybersecurity and privacy risks. And you're adapting to new ways of collecting data and different ways of disclosure practices, which all creates an overall risk for privacy breaches. In response to the pandemic, there are a lot of vendors out there who are also adapting. They may not be compliant, and if healthcare providers are doing business with different vendors that are not compliant with privacy and particularly HIPAA, then that does provide additional exposure to you as providers. Not to mention, because of COVID-19, the statistics have shown that there is more cybersecurity attacks and more exposure for data privacy exposures, because let's be honest, there are a lot of bad people out there, and with bad people, they want to take advantage of vulnerable situations. And with COVID-19, if some of the changes, it does present itself as certain vulnerabilities in a multitude of different industries, healthcare not being an exception. So looking down the road in response to these concerns, what the federal government did is they're taking action to encourage, in some instances require, organizations to make more of a concerted effort to monitor and resolve and respond to cybersecurity attacks. What does that really mean for you? It means that you have to actually put in more resources, create more policies and procedures, identify someone within your organization to serve as a liaison to monitor potential cybersecurity attacks, identify some good privacy practices, and identify certain security measures on how you're holding and securing PHI. In my experience, home healthcare agencies have traditionally not put a whole lot of effort into this, and I think moving forward, you're going to see more businesses in this industry being more severely impacted by this particular area of the law. Because your workforce is always transient, if you really think about it logically, a lot of your workforce is moving around from point A to point B. It's that nurse that's going from Mr. Jones's home to Mr. Smith's office, and they stop along the way at a gas station. They put their laptops or their smartphones on the passenger seat, potentially putting those pieces of equipment in jeopardy to be stolen, or to somebody to hack in if it is stolen. So because your workforce is so transient, that does provide additional risk that other industries may not see. So factors for privacy and security risk, as I said, there's malicious actors, use of personal devices and unsecured public and home networks, increasing number of ransom attacks. So if you think about it, bullet 1 and bullet 3 are congruent and are related to one another. Encrypted files in network, or really unencrypted files. The lack of encryption it puts you at risk. So if you're not using encryption software, that's something you should think about. Data draining, that means exfiltration of data to your home computers, and everybody's home computers varies in different levels of security. If you do have secured PHI, or just PHI in general in your personal accounts, and your husband or your wife accesses that computer, or your kids or your teenagers, that's all, those are all grounds for cybersecurity risk. Why? Because they're not an authorized party to access PHI, and you've just sent PHI that was supposed to be in a secured and work account to your personal account. So something to think about, and that goes the same with text messages as well. Now the good news is, because of COVID-19, the regulators, specifically the Office of Civil Rights under the Health and Human Services, they are suspending enforcement for the time being of certain security and privacy regulations, as long as you show, the key buzzword is good faith standard. If you look at all the changes in response to COVID-19 as it relates to privacy and cybersecurity risks, it's always using good faith to do this, good faith to do that. Using the use of telehealth, where you can use now, under the regulations, you can use FaceTime. Well, if you're using FaceTime in a crowded restaurant, that's very different than using it in the privacy of your office, right? So the contrast of the two, scenario 1, it's arguable that it's not good faith use of the use of technology and practicing in the world of telehealth. Whereas scenario 2, you are exercising good faith. And if somebody were to walk in, that doesn't necessarily breach that good faith standard. It just means that something happened, but you went out of your way as a provider to find the most secure, find the most private area to conduct that session. So think about the good faith exercises that you're utilizing when you're making an attempt or making a good faith effort to maintain the integrity of privacy and cybersecurity issues. Are you doing risk assessments on a regular basis? If you're not, that's something you should think about. Of course, under HIPAA, there are situations where you're forced to disclose information. Let's just say, hypothetically, the CDC wanted information. You can disclose that. There are many exceptions under HIPAA. That's one of them. There are others. The one that's regularly used by providers, such as yourself, is what's called the Tpo exception. As long as it's used for treatment, operations, or payment, you can actually send, receive, transmit PHI without it violating HIPAA. Again, this goes back to my emphasis at the beginning of the discussion that the law and the legal world of healthcare, there are just so many different exceptions and different nuances that it's very fact specific. So something to keep in mind. Privacy and cybersecurity tips. These are some of the tips that I would suggest that you assess within your own organizations, backing up your data, password management, having someone to look over your training logs and devise a plan, having policies and procedures, looking at your antivirus software. These are all just tips that you can help yourselves or get a professional to come in, and these are some of the issues that you can bring up to the privacy or cybersecurity professional if this is something that that you want to take up as an additional precaution within your organization. So we're going to jump right from privacy right into healthcare fraud. Now this is kind of the area where I've probably been the most involved with this area, and obviously for those of you who have attended other HCL events, I'm very involved with this particular area of the law, and also in particular with transactions dealing with CHOWs and buying and selling home healthcare agencies. So this is kind of like my baby, and this is along with some of the transactional work. And I can't emphasize enough that 2019 was a very busy year, like it has been for the last 10 years. But I think more importantly, what we should discuss is, what does it look like post-COVID-19, right? Post-COVID-19, and as it relates to the CARES Act and some of the other things other items that's within the industry, how does it impact you? Before we get there, let's have a review of 2019 and what occurred last year, and it gives you a background and it paints a landscape of what is to come. So last year in 2019, the federal government recovered a little bit over $3 billion, which is an uptick from 2018. About 2.6 of that was from healthcare cases alone. That's about 85% of the $3 billion. Since 1986, when the False Claims Act, which I titled the FCA. By the way, when I reference the federal government and use the acronym DOJ, that's Department of Justice. And so if there's any acronyms that you're confused by, or you're not clear on why I'm using certain acronyms, feel free to ask. DOJ recovered more than $62 billion under that statute since 1986. Last year was the 10th consecutive year that the FCA recovered to over $2 billion. And as a point of clarification, the only reason they used $2 billion versus $3 billion is because in 2018, the federal government under the FCA recovered 2.9. So thereby, it didn't keep that $3 billion consecutive. Had it been $3 billion, it would have been 10 consecutive years under the FCA recovering in excess of $3 billion versus 2. The government paid out about $198 million to relators. Relators are essentially whistleblowers. When you hear the word key TAM cases, those are the cases that's brought to the federal government by a whistleblower. A whistleblower, not always, but about 70% of all key TAM cases also derive from whistleblowers. And a whistleblower can really be anybody. It's been shown that a vast majority of whistleblowers or relators in healthcare have been employees or former employees. Sometimes it can be upper management. Sometimes it can even be a silent partner. A relator can be anybody. Just know that why that's important is because relators or whistleblowers are incentivized to bring healthcare fraud to the attention of the government, because ultimately they individually get paid if it's a success. Direct file cases went up by 18%, or 18.7% in 2019, and there was recovered money by Medicare, Medicaid, and TRICARE, although it varies. I don't see TRICARE a whole lot in home health, but I'm just letting you know that TRICARE was part of that recovery. The Texas Office of the Texas Office of Attorney General, the Medicaid Fraud Control Unit, recovered about, I guess it's about $140 million in 2019. That's just state Medicaid money. And the Texas Health and Human Services Commission, OIG, executed 48 settlement agreements for a grand total of a little bit over $6 million. Okay, so in 2019, targeted industries included drug and medical device manufacturers, managed care providers, hospitals, pharmacies, hospices, laboratories, and physicians. Those were the big target areas. Two of the largest recoveries in healthcare industry this past year came from settlements with opioid manufacturers. So opioids were the big bad actor, I guess you can say, in 2019. Of course, in 2019, there were about 636 key TAM cases. I'm going to skip over some of the materials. You can read for yourselves because for the sake of time, I think it's probably within your best interest. I don't read over every little detail. So let's talk about COVID-19 and healthcare fraud. Earlier in this year, the U.S. Attorney General issued a memorandum on fraud in connection with COVID-19. The FBI established what's called the COVID-19 Working Group, which is really comprised of FBI offices and other participants from the Department of Justice to fight criminals that take advantage or that have presented some level of fraud in connection with COVID-19. In particular, it can be either providing false COVID-19 tests or lying about the financial situation to obtain money under the CARES Act, or a lot of it is just PPEs as well, providing PPEs that fail to meet CDC standards. So it's very broad in nature. It's not one particular thing. Around in late May, the FBI Internet Crime Complaint Center, they call it the IC3, received about the same number of complaints in 2020 by the middle of the year as they did for the entirety of 2019. About 75% of these complaints were related to fraud and swindles, and that swindle is going back to providing false COVID-19 tests and PPE related, more or less. So the PPP loans, and I'm sorry that I left out a P, but instead of PP, it's supposed to be PPP. Healthcare fraud under the PPP involved EINs that were already being used to obtain fraudulent loan applications, fraudulent websites claiming to facilitate PPP loans, which gather all the necessary information that helps you apply for the PPP loan. So there are some bad actors out there that says, hey, come to me, pay me X amount, give me all this information, and I'll help facilitate the PPP loan. So that's another aspect of COVID-19 healthcare fraud. There's also what's called the Beck Schemes. It's really the prepay scam for either goods or services. You pay me first, I'll give you whatever service and whatever good that you're paying for. And they're using a legitimate email. It looks completely legitimate, but they're actually, it's actually fraud. Money mules are being used. Money mules, the money mule is essentially the person that's working from home and may be out of a job, that may have a little bit more time on their hands. They get approached by a third party. It says, we'll give you, a certain amount of money. You deposit it. We need you to get this money to another party, and you keep a certain percentage. So as an example, if you're a money mule, somebody could approach you and say, we'll give you $10,000, we'll deposit in, here are the checks. You take the checks, you deposit it, you keep, say, 20% of that, so that's $2,000. You give the remaining $8,000 to another party. To the average person who's serving as a money mule, that may sound great, especially if if they're not as busy, or they're out of a job, or if they got furloughed. They thought, oh, it's a quick $2,000, when in fact the check that they send you, usually either through like UPS or some other type of courier service, those checks are actually fraud checks, and it may clear, and then 5 days later the bank or the financial institution will ask the money mule to pay the money back. That's the money mule scheme, which happens in healthcare. It's already happened. Healthcare fraud in general, collecting and use of personal information or personal identifiable information to build federal healthcare programs, i.e. Medicare, or insurance plans for tests or procedures that individuals didn't actually receive. That's been going on. Scammers, as I said, involving at-home test kits are also in play as part of the healthcare fraud. So moving from fraud to contract disputes, this area is more or less what's going on daily and what's happened since COVID-19. These are the scenarios where you had an agreement with some third party, you had an agreement with a vendor, you had an agreement with maybe a therapy provider that's providing subcontracting therapy in the form of OT, PT, and ST. And now under certain commercial situations, or because lack of cash flow or or bad circumstance, certain people can't perform. And performance could mean I just simply can't meet up my end of the bargain and give you what you ordered or give you what you paid for. Or conversely, the provider is not being paid for providing the good or service, and the payor or the buyer of this good or service is now looking for an out, saying, I can't pay you because of poor cash flow. So it goes both ways. So in the contract dispute issues as it relates to COVID-19, contracts usually contain provisions addressing unforeseeable events such as COVID-19. Let's be honest, about a year ago, who would have ever predicted COVID-19, a pandemic, would have hit the world and would have impacted a lot of people, millions of people? I don't think anybody would have been able to predict that. Nevertheless, it's happened. Now, because it's happened, these certain provisions and agreements are being reviewed, because if COVID-19 can happen, then something in the future could happen that's related to COVID-19, or maybe even worse. So as far as excusing performance, whether it's to pay or to provide a good or service, the contract has historically contained a clause in there, and you may find it at towards the very back of any agreement. It's probably usually like a provision number 11, 12, or 13 that's called the force majeure clause. And what that does is it relieves the liability of the performing party, or really in the case of a non-performing party, because of an unforeseeable event. The perfect example is this. I'll give you a perfect example. Recently, I have a client that's a professional association, and they are having a conference at a particular hotel later on this year. And because of COVID-19, the members of this professional association are either choosing not to attend the conference, or their employers now won't let them attend the conference, putting the professional association in a predicament that they can't actually hold the conference now at the hotel. Now, the force majeure clause will kick in, saying, because of an unforeseeable event, the party has been put in an unpredictable situation, and they can't actually go forward with the deal. Nevertheless, the contract still exists. Both parties came to the table a year ago and signed this contract. The question then becomes, is the professional association excused from paying the hotel fee and going forward? Some different agreements will have different provisions. In that situation, I believe there's a penalty clause, but nevertheless, a penalty clause is a fraction of what they would otherwise have been on the hook for had there not been that specific provision allowing them to not hold the conference and not pay them the conference fee, and because of an unforeseeable event. Again, this provision can be written very specifically, or it can be written in a very general fashion. And when it's written in a general fashion, it creates a lot of ambiguity, and that's where really the fight is. Because of ambiguity, because of unclarity of what is deemed an unforeseeable event. Is it a pandemic, or does it not include a pandemic? So that's really what people are fighting over a lot of times in these contract disputes when COVID-19 hit. So let's talk about material adverse event or other form of hardship that can provide grounds for termination or renegotiations. The term of impossibility of performance as it relates to the hotel example is it's an arbitrary one, because one can argue that the the professional association can still go forward with the conference, even though they would have a low attendance. So the question then would become, is it impossible to perform? The term material adverse event is very, very important, because anything could be an adverse event, but is it material enough? Or meaning, does it have enough, strong enough impact? If nobody were to attend in that scenario, or in that example I gave you, I would argue that it would be material to having the conference. If it's just a mere insignificant burden, for example, if you have to move the date around, then that wouldn't be an impossibility of performance. You can still have the conference. It just may not be the exact same date that you originally agreed to. So you have to look at the facts associated with why someone's not performing, or why someone's not paying, or why someone's not providing you the good or service. Again, very fact specific, and it's different for everybody. Disputes rest on the unforeseeability and are fact specific. I just said that. And that those are the quote triggering events. If something is truly unforeseeable, then that may trigger that provision. But if it is foreseeable, if you foresaw it 6 months ago, then that provision, the force majeure clause, may not even be in effect, because something was foreseeable. So again, fact specific, and these arbitrary terms have to be very well defined in these provisions. Are there commercially reasonably alternative to minimize the effects? Can you maybe still go forward with the performance, but something you can change something different about how you do it, or within a time frame that you do something, thereby not making the performance impossible, but it's just maybe slightly different. Giving notice within a reasonable amount of time is actually very, very important. So notice given from party to party in these contract disputes is very critical. So for you, I think the takeaway for you as the business owners is, if there's a potential contract dispute, look at the notice. Are you putting this in writing? Are you emailing them, or did you give them a call? If you gave them a call, then there's no records of it. Then it becomes very hard to argue that your performance is excused. But if you did provide them notice saying, hey, listen, because of these situations, we are unable to perform, thereby I'm giving you the chance to go and find another provider for this service, for this good, or I'm giving you another opportunity to mitigate the situation, because I'm not going to be able to pay you, and so maybe you need to sell the goods or service to someone else. So giving notice and having that ongoing direct dialogue of documenting why something is not being performed is very, very critical. So contract dispute tips during COVID-19. I told you the material adverse effects is very important. Force majeure notices, parties seeking to be excused, to excuse their obligations, is absolutely critical. So if you're triggering that force majeure clause, you absolutely need to provide notice. So going back to the hotel example and that professional association, it was very critical for that professional association at an early enough stage to provide notice to the hotel saying, hey, we're not going to go forward with the conference, and this is why. And allow the hotel to come back and say, well, you have to, or that if you don't, these are the potential consequences. And that's where the negotiation or the communication starts, because then everybody's put on notice that performance is not going to occur. So renegotiating contracts, define very carefully in the terms what's being considered a covered event. So when I say covered event, we'll just use COVID-19. If COVID-19 was foreseeable, let's just say hypothetically COVID-19 was foreseeable back in November of last year, then it becomes harder and harder to trigger that force majeure clause, because it's arguable that COVID-19 was foreseeable. However, if nobody saw it coming until it happened, which is when it did, which For most of us, it started impacting everybody in, I would say, first or second week of March. Then that could be a covered event. So it depends on how you write that provision on what's defined as foreseeable, what's defined as a covered event in that force majeure clause. Plan and understand your course. So if you're going to litigate these contracts, if you're going to dispute something, you have to understand who your audience is. Because a lot of courthouses are closed, or they may have altered the way that they're going to handle certain hearings, or how they're going to handle certain judicial processes, you need to find out if it's going to be in person or if it's over Zoom. Is it going to involve taking depositions? Why? Is because it allows you to plan ahead, and also allows you to budget, and allows you to adequately prepare for these situations. It could very well that you may need a TRO, a temporary restraining order, or lifting a TRO, meaning there was a TRO and you have to fight a TRO. So those TROs and temporary restraining orders are tools that businesses use to essentially maintain the status quo. So in the example of the force majeure, one party may file TRO in explaining in the TRO why one service has to move forward, and the court will, if granting the TRO or if allowing a TRO to be approved, then in the order it would force one party to perform even if they say they can't. So that's just something to think about, because that's been happening in these contract disputes in response to COVID-19. Okay. Does anybody have any questions at this time? I'm gonna take somewhat of a 2-second mental break before we jump into the thick of it.
Richard, I don't see any questions in the Q&A panel. Can you guys hear me okay? Okay, I'm getting a lot of feedback on my end. I do see that one person had their hand raised, and we don't really have a way to unmute them and let them talk. So if you do have any questions, please put them in the Q&A panel, but I don't see any at this time.
Okay, that could be either really good because I'm thorough, or it's really bad because I've confused everybody. So either or, we're moving forward. Okay, that gave you like a 1-minute break, and so we're going to move forward with a very big topic. It's it's a topic that it's going to impact a lot of you. That's probably already has, and I can't emphasize enough that there is somebody. I'm seeing somebody. Okay. You're doing fine. It's a lot of info. Okay. All right. So going back to the Family First Coronavirus Response Act, this is what I've been referencing as the FFCRA development, and this is really that second big piece of legislation when COVID-19 hit. What I'm about to present to you in these 5 bullet points are just the very big, broad overviews of what contained in the FFCRA. I will go ahead and give you a disclaimer right now that some of this has already changed, okay? So in other words, at least one bullet point will no longer apply. Nevertheless, I wanted you to understand that this was part of the original piece of legislation. This was part of the original rulemaking under the FFCRA, and that in the FFCRA, they even specifically said that this is a temporary set of regulations and it's subject to change upon further rulemaking. And that further rulemaking occurred on August 3rd, which we'll touch on later on in the presentation. And I'll explain, and you'll see why it's changed. So as part of the FFCRA, it confirmed that there's no entitlement to leave where the employer, and I'm going to emphasize that you're going to see a lot of acronyms with ER or EE. ER means employer, EE means employee. I'm going to say that again. ER means employer, EE means employee, because you're going to see a lot of that. So the original legislation said FFCRA does confirm that there's no entitlement to leave where the employer does not have work for the employee. such as where the business is temporarily closed. That is an employer-friendly piece of rulemaking. That is the one that has changed after August 3rd, and I'll explain why, and I'll explain even how later on. So moving on, FFCRA actually clarifies that mass shelter in place or stay-at-home orders what it means. It's considered a government quarantine or isolation order under the FFCRA. Another thing it did is clarify the treatment of affiliated entities for the purposes of calculating the number of employees. Why that's important is because under the FFCRA, if you have under 500 employees, you're deemed a covered employer. However, the question is always, how do we calculate, how do we properly calculate whether or not we're a covered employer? And there's it's not, does it include temporary workers? Does it include that employee that we use from a staffing agency? Does it include independent contractors? So different ways of calculating employees as part of the quote head count in that 500 employee threshold that either qualifies you or disqualifies you as a covered employer that subjects you to some of these obligations. So for the treatment of calculating number of employees, separate corporations are generally treated as separate entities unless they meet the joint employer test under the Fair Labor Standards Act. Generally, the joint employer test is a threshold that the Department of Labor looks at to see whether the two different entities have a certain degree of control and dominion over the employee. The perfect classic example in home healthcare is always going to be the home healthcare provider that uses a staffing agency that comes in. Staffing agency is the payroll employer. Nevertheless, the provider home healthcare agency is the on-site worksite employer, dictating, no, we don't want this therapist. No, we don't want this person. We want this person instead. There is that degree of control. There's another one called what's called the Integrated Enterprise Test under the FMLA, or the Family Medical Leave Act. That's really looking at the overall enterprise of an organization. The classic example is the mothership or the parent company that owns, let's say, home health care agency 1 and hospice 2, or it could be, you know, 2 home health care agencies. Even though the home health care agency 1 is under one legal entity, it's so connected to the other one that you have to, because of the nature of how it's structured, you have to count the number of employees at both agency 1 and agency 2. So instead of counting solely within agency 1, you have to account for both of them as your total head count. It also clarified that the employee who is advised of self-quarantine because the employee may be particularly vulnerable to COVID-19 is eligible for leave. And it also clarified the documentation requirements as well. Okay. So the FFCRA really had within the FFCRA, there were really 2 other pieces of laws that were developed. And that was Epsilon, or the Emergency Paid Sick Leave Act, or the EFMLEA, which is really an expansion of what already exists under the FMLA. But because of COVID-19, the FFCRA created really 2 benefits to employees. And it's really the whole legislative intent, or the intent behind creating the FFCRA, is really finding a balance for a couple, in a couple of ways. One, it allows the employee to keep their jobs and to maintain their employment despite the downward turn of the economy and the effects of the pandemic, both from a healthcare standpoint and from a financial standpoint. It also allows the employer to keep their businesses running, and at the same time allows them to create some safety measures within their organization to allow either certain employees to work or not work because they could present themselves as a threat to the workforce. And keep in mind, these two pieces of laws, it doesn't just apply to healthcare, it's across the board. So benefit number one is really the Paid Sick Leave Act, or let's just call it the Paid Sick Leave. And it's entitled to everybody. Every employee is entitled to up to 2 weeks, or really 10 working days, to take up to 2 weeks of paid sick leave. And of course, this is in effect through the end of the year. The other one, the EFMLEA, really amends the FMLA and permits the employee to take up to 12 weeks of expanded family medical leave. And 10 of those 12 weeks are paid, as long as the reasons for the leave is related to COVID-19. And of course, the FFCRA only covers private employers with fewer than 500 employees and certain public employers. It doesn't cover governmental employers because Title II covers that, so it doesn't apply to governmental employers. I think I have a couple of questions. So somebody asked me a very specific question. Okay, I'm going to say that somebody has asked me a very specific question pertaining to a contract with a company for healthcare insurance, and they wanted my opinion. I can't emphasize enough that this requires very specific one-on-one dialogue. It's very fact specific. So I'm gonna try and do my best to give you some highlights, but let's wait until the very end. And again, this is the purpose of this presentation is really not for me to provide a very specific fact analysis of your particular situation. I'd be happy to give you some general guidance, but for the time being, we have to be fair to everybody and we have to cover plenty of material. Let's see here. Okay, so let's break down the paid sick leave, the paid sick time. So 80 hours is all you're entitled to. But whether or not you get paid a regular rate of pay or 2/3 of the employee's regular rate depends on why you're taking that paid sick time. So in scenario one, under the Epsilon bucket, if you're using the paid sick time where the employee is unable to work because the employee is isolated or quarantined, or experiencing COVID-19 symptoms and seeking medical diagnosis, you get paid your regular rate. So the employer has to pay the employee their regular rate. And how you calculate that regular rate is you really have to look at their historical, their historical pay that includes overtime as well. So you have to do an average of their regular pay. And for those who are being paid by commission, that's something to also look at, because if they're getting, you can use, I believe the guidance is usually 6 months, is you look at their 6-month trending history of how they got paid, and that's how you calculate their average rate of pay. Now, if the employee is going to be paid 2/3 of their regular pay, it's because the employee is unable to work because of a need to care for another individual that's subject to the quarantine or the isolation, or it's to care for a child under the age of 18 whose school or child care provider is closed or unavailable because of COVID-19. So that's the triggering factor. If they're closed or unavailable and it's not related to COVID-19, then it doesn't apply. Or the employee is experiencing an entire host of different other reasons that's somewhat related to that. And there's a list that's associated with the Health and Human Services and the Department of Labor as well. So that's really the Epsilon bucket of time and pay. It's up to 80 hours. Once you've used your 80 hours, it's done. It's gone. Okay. There's no. You have to then look at some other, for the employee. They have to look at some other options for payment if they were to take time off, either under the EFMLA, LEA, or for if they have a bucket of pay time off as an employee. So under the leave bucket of time, it's up to an additional 10 weeks of expanded paid FMLA leave at 2/3 of the employee's regular rate of pay. And this only applies if the employee has been employed for at least 30 calendar days. It doesn't mean they have to work for 30 calendar days. It just means that they have to be employed for 30 calendar days. So as long as they're on payroll for 30 calendar days, then that's fine. And it's because the leave is because of a need to care for a child, or because the child's school or childcare is closed or unavailable because of COVID-19. So I know that threshold correlates, and it kind of bleeds over from the Epsilon bucket. But if you notice a difference, the EFMLEA, it does not include the individual or the employee himself or herself. The guidance makes it clear that for 10 weeks of paid leave, the employer must include whatever hours the employee typically works during the period, including overtime. Okay, so this is going back to the Epsilon. These are the 6 scenarios where the paid sick leave can actually be triggered. So under the Epsilon bucket of time, the 80 hours, it's when the employee is unable to work because of isolation or quarantine. It was advised by a healthcare provider that he or she shouldn't work, or is experiencing COVID-19 symptoms and is seeking medical diagnosis. So if you notice 1, 2, and 3, they're all very individually based. Whereas bucket 4 and 5, or items 4 and 5, it's really used to, the need is really to address someone else's care. So in 4 is unable to work because of a need to care for an individual that's subject to governmental quarantine, or has been advised by a healthcare provider to self-quarantine. Okay, so it's the need to care for someone else. Just like 5, it's related to the need to care for the child because the school or the child care is closed as it relates to COVID-19. So in comparison, between Epsilon and the EFMLEA is that the EFMLEA can be used only where the employee is unable to work or telework due to a need to leave for to care for a son or daughter of the employee if the school or the place of care has been closed. Again, it's less individually focused. So if you think about it, the Epsilon time is much broader. There are a lot more reasons why you can trigger that, and it also doesn't require you to work for 30 days. It's actually available upon the first day of hire, whereas the other one you have to have worked for been on payroll for 30 days, and it's due to the care for someone else. So when calculating the employer to determine whether or not you're a covered employer, the employer has to include all employees who are on leave, all temporary employees who are jointly employed by the employer and another employer. It's that classic staffing agency example that I gave you, and all day laborers supplied by temporary employment agencies, and independent contractors are under the FLSA are not included. And also 2 ways to calculate the employees. As I said, it's the joint employer calculation, or it's the integrated employer test. It's that entire enterprise structure. If you have common ownership of multiple entities and there's some degree of common ownership or financial control, then employees could be counted towards that 500 employee threshold. And in some instances, as the business owner, as the employer, you wanted to, because if it's over 500, then you're not obligated under some of these laws. So now we're going to go into some Q&A. These are essentially questions, and then it'll give you some answers. And this may shed some light regarding some of the questions that I see posted already. So question 1, at what point in time should the employer take account? So the employer should count their employees when the employee's leave is to be taken. This means that if an employer is hovering around 500 employees, and you have to pay attention to this, because if you're hovering around 500 employees, you need to self-monitor this to see whether it goes over or under. because if at the time the employee needs to take a leave and the employer has 500 or more employees, but then the headcount drops below that 500 and the employee still needs leave, then you have to provide it. Now, it's not the same in reverse though. That's the bad part. It doesn't work the other way. What qualifies as 30 days for purposes of the EFMLEA, employee eligibility? Well, the employee must have been on payroll, again, anytime worked as a temporary employee, or the employer also counts as being on payroll for 30 days, no matter how many days he or she has worked. Do temporary workers count towards the total? Yes, the employers are required to count all temporary employees in the total, even if paid by a temporary services agency. And there's an entire analysis underneath, but we're running a little bit shorter on time, so I'm going to move forward. What type of emergency leave does the EFMLEA provide? So the FFCRA amends the existing FMLA. We already have the FMLA to grant emergency FMLA leave when the employee needs to care for the daughter or the son, as it relates to a public health emergency, such as COVID-19, right? The leave offered here is the same as the leave provided under the Epsilon leave entitlement for school or child care closures, because if you remember, both Epsilon and the EFMLEA both have that entitlement to leave because of child care or school. And it has to be taken between April 1st and the end of the year. And by the way, leave provided prior to April 1st, it doesn't count towards the leave that's granted thereafter. So you can't say, well, I gave my employee 1 week off, so therefore now my employee is only entitled to 11 weeks after April 1st. It doesn't count. So is EFMLEA leave paid or unpaid? So we already talked about that it's paid after the first 2 weeks have already been taken. So the first 2 weeks are unpaid. It also, and then the remaining 10 weeks it is paid at a 2/3 rate. Okay, so if an employee is furloughed, does he or she qualify for leave? So this is one of those other ones that has changed. So when originally the EFMLEA was created under the FFCRA, this is absolutely true, okay? So originally the DOL said that the furloughed employees do not qualify for leave because there's just simply not enough work, and because the employer doesn't have the work for the employee. So the answer to this question is actually incorrect. And why it's incorrect? Because as of August 3rd, it changed, and I'll show you why. Must eligible employees be paid under Epsilon? So if an employee is eligible for Epsilon leave due to his or her own inability to work, and that goes back to reasons 1 through 3, as I pointed out, they're very individually based. The employer must compensate the employee for any sick time that he or she takes. However, as I said here, to determine the employee's average regular rate, the employer can use the Fla method of calculation, which is subject to the 6-month rule review. So how you do the 6-month review is to determine to look back over the last 6 months to determine the employee's average regular rate. If the employee has not been working for 6 months, the employer should look back over the employee's entire employment period, okay? Once the employer determines the employee's total compensation, then it can divide it by the number of hours the employee worked to determine the wages, and it's capped off at $511 a day. However, if the employee is absent from work to care for others, so it goes back to that reasons 4 through 6 in slide 17, and keep in mind, this is just pertaining to Epsilon, not the other one. The employer must compensate them for any paid sick time that they take at 2/3 of their average regular rate. So you still use the same way that you calculate the average rate, looking at a six-month look-back period, and you pay them at a 2/3 rate, 66 and 2/3% of that average rate, and it absolutely caps off at $200 per day. Does unused Epsilon leave carry over to subsequent years? Short answer is no, okay? And it tells you why right there. If an employer previously provided paid sick leave, what if the employer previously provided paid sick leave? Well, under Epsilon, leave under the FFCRA is in addition to any paid sick leave already offered. So it doesn't mean that if you give an employee sick leave that it's offset by the Epsilon mandate of 80 hours, because that's an extension of whatever they're already entitled to. So this is the new development I was talking about. So in mid-April, the Attorney General in New York filed a lawsuit against the Department of Labor in a federal court in New York, saying that the agency exceeded its rulemaking authority. So all these different rules and all the obligations that's been identified through these laws is really the result of the Department of Labor making these rules. Well, the question then becomes: does the Department of Labor have the authority, or do they have the ability to create these rules, or does it exceed the scope of their authority? And so the Attorney General in New York really challenged it, and how she challenged it is by saying that there's really 4 aspects of the rulemaking that we don't agree with. And the 4 aspects included the work availability requirement, thereby changing some of the answers that's already in the slide, particularly the first slide that referenced the FFCRA and one of the questions pertaining to furloughed employees. It also challenged the definition of a healthcare provider, the prohibition on intermittent leave, and really specifically the consent that's required, and the documentation requirements that needs to be provided. So the New York claimed that each of these 4 provisions either limited paid leave or burdened its exercise, forcing employees to choose between taking paid leave and going to work even when sick. And their argument is that it defeats the purpose of the FFCRA and really the legislative intent behind it. So on August 3rd, the U.S. District Court of the Southern District of New York, it's a federal court, okay? The decision was rendered by a federal judge, issued a decision vacating certain aspects of the Department of Labor's regulations. In other words, the judge said, we don't agree that the Department of Labor had the authority to establish these requirements, or to establish these requirements that allow the employer to, for example, to force the work availability requirement on the employees, and to provide some of these other obligations when an employee is seeking intermittent leave, or having the obligation to provide some of the documentation that they were originally required to provide. So let's just go through one at a time. So what the court really said was, before there was a work availability requirement, okay? If basically, in other words, if the employer didn't have the work available for the employee, then the employee wasn't entitled to leave. However, the court said, whoa, wait. The work availability requirement to qualify for paid sick leave is invalid now. So going back to slide number 17, I know I've referenced slide number 17 a lot. It applies to 1, 4, and 5. And 1 is, from what I remember, is specifically to the self-quarantine and the self-isolation. And 4 or 5 pertains to the care for others, or the care for the child because of unavailability of the school or childcare. So in this, from this respect, the court basically said, now the employee may be entitled to leave even if the employee is not scheduled to work. So in other words, if you have employees that's not scheduled to work, or the work is simply not available, that in itself does not absolve you from the obligations to provide them with paid leave. This change is actually employee friendly. So it should, as business owners, you should have your antennas up saying, well, wait, we need to look at this because now some of these things have changed. Maybe it's not how we've been operating because of what was originally announced under the FFCRA. So this is something that's changed in favor of your employees. So it should alert you a little bit. It also changed the employees' the employee's obligation to secure the employer consent for intermittent leave. Before this decision, the employers had to provide their consent in order for the employee to secure intermittent leave. Under this court's decision, and validated the requirements for the employer's consent for intermittent leave. And this is not the paid sick leave, this is the intermittent leave. And so now the employer must allow intermittent leave unless the employee's specific circumstances appear to create a higher risk of viral infection. So if a certain situation came up and the employer said, well, if you were to take this leave, there's a greater chance you may come back and provide a bigger exposure to this business or our customers or patients, then that could be grounds to deny the consent. However, I think as business owners in this industry, I think you should keep in mind those circumstances are very narrow, and it wouldn't be with your interest to interpret those situations in a very broad fashion. Okay, the definition of a healthcare provider was overly broad. So what the court basically said was the definition of a healthcare provider as far as emergency responders or employees, it was overly broad, and you can't include everybody in a healthcare organization to absolve you of your obligation to provide them with leave. So before, under the FFCRA, if you qualify as a healthcare provider, as the healthcare provider, you may or may not have had the obligation to provide them with leave, but you may, as the employer, you may elect to do so. Under the court's decision, the court basically said, you as a the term healthcare provider is way too broad. We can't include the person that's working, say, in accounting in a university that happens to have a medical hospital. Is that a healthcare provider? And there's just simply not a close enough connection. Or what they used was the term, there's not a close enough nexus between healthcare services and that employee. So what it ultimately said was, as a healthcare provider, you have to address this on a case-by-case scenario. If on a case-by-case scenario, you choose to fall under this bucket because you can come up with appropriate justification for it, and that's fine. But what it really did was it narrowed the scope of what's deemed a healthcare provider. So the last one is the documentation requirement. Employees, before the employees submit, they're required to submit a reason and a duration and a source of authority of why they're taking the leave. So very burdensome. You have to, as the employee, they have to come up with all these different documentations to show, how long I'm going to be gone for, why I'm leaving, and so forth. However, the court held that the FFCRA only requires the employees to provide notice before taking the leave. So substantially less documentation requirement. The employees just simply has to tell the employer, I'm taking this leave under the EFMLEA, and the obligation to provide the duration, the reason. It's not really required anymore. Although, if you don't know how long, I would argue that if you don't know how long the employee is going to be gone for the duration, then that could be very problematic as a business owner. So what are you going to do as a business owner as for employer strategies? You should take into account some of the changes like we just talked about. You should monitor the legal challenges that's going on along the way, because there probably will be changes. You should monitor the Department of Labor's announcements because they come out with regular announcements. This is not one of those scenarios to where it's, you have one set of rules and that's that. It's going to change. It's a very fluid and it's a very fluid and ongoing changing area of the law, and it could change from week to week, and depending on because of politics, because of a lot of other moving parts. So you shouldn't sit there and just expect it to remain static. You should expect it to change along the way. You should also review your existing workplace policies on how you're handling some of these employee-employer issues. Again, we're not here to become experts, and everybody has a different scenario. Everybody has a different set of facts. This is really the time for you to be able to issue spot, say that could be an issue, or this could be an issue. Maybe I need to go seek help. And as far as the overall market is concerned, I know that I didn't put this in the slide, but I do want to say that there is still there's still plenty of opportunities in this industry for transacting and for selling and buying agencies. The capital markets in this industry, despite COVID-19, is actually still relatively healthy. It was actually anticipated that 2020 was going to be a very good year in this industry from a capital market standpoint, and it still is, but people are just gun shy about it, and because of what's going on. But I do want you to be aware that that's something that's still available. I think other than that, this is my my firm's website, and that's my email, that's our phone number. And there's going to be a bonus session, I believe, provided by Amy. And I think this is actually session number 6 because, well, actually this is, I'm not sure. I guess this is session number 7. Well, it says right here that session number 7 is going to address then the pandemic psychosocial impacts while rebuilding agency operations.
Hey, Richard, we do have a whole lot of questions if you got time to go through some.
I will go through some. I see there's 21 different questions.
Right. Okay. You want to start at the top? Do you need me to read them to you? How do you want to take them?
No. What is the current definition of healthcare worker and those who the leave requirements don't apply? Healthcare worker, it's actually a very long list. It's anybody that's actually, if you look at the definition of a healthcare worker, it's any healthcare provider, okay, that's employed by a hospital, a skilled nursing facility, a lab, so forth. It's a very long laundry list of different types of providers that can trigger that healthcare provider. The point, I think that's a very good question, because the whole point of that August 3rd decision is that it's saying that the original definition of how you define healthcare providers is substantially broad. It's too broad. In fact, the court even used the example of, well, does that secretary that works for the university that happens to have a university hospital that provides healthcare services, is that a healthcare provider? Well, according to, because of that example, what they really did was they narrowed the scope of what's deemed a healthcare provider. In fact, they specifically said that healthcare providers should use a case-by-case scenario to address on what needs to be done or what should be done. Because keep in mind, as a healthcare provider employer, you are given the discretion of allowing the leave, because if you truly fall under the healthcare provider bucket, it may exclude you. It may provide you the ability to not provide certain types of leave depending on the type of employee that you have. What if after using all of the possible calculations, you do have less than 50 employees? Are we still exempt? That is the New York ruling did not address the exemption. There is a 50 employee exemption, but you have to apply for that, and you have to show why there's a financial burden or how it would adversely impact your financial situation or your operations if you were to provide the leave or the pay sick leave.
And remember, there's a tax credit for those.
There you go.
To offset the cost.
Yeah. So it is you have to apply for that. You have to show why you qualify for that, basically. This question goes into a lot of detail. I had a contract with a company for health insurance for my employees, but due to COVID-19, most of the employees are no longer in the company, but the insurance company still wants the agency to continue to pay for the employees that are no longer working for the agency. What is your opinion on this? My opinion is that you need to look closely at your contract. I think you need to work out the details with your insurance company. That is a very fact scenario situation that is beyond the scope of me answering these questions. Do sick leave and expanded, does Epsilon 2-week leave also have to be COVID related? All of it has to be COVID related. From the opening session information, is there an educational handout regarding privacy, cybersecurity technology that is available that we could hand out to our employees? You may want to look at the IAPP. It's an organization, but keep in mind when you're tailoring privacy and cybersecurity education, there is generally some good education through either the IAPP or the HCCA, which is the Healthcare Compliance Association, specifically on HIPAA. But you really need to do a very good job of tailoring it to your individual needs. I wish I could sit here and tell you here's a template and this is the template that you need, but it's not that simple. If it were that simple, there really wouldn't be a need for these professionals that come in to assess your privacy needs. But I would start with the IAPP or the HCCA to address cybersecurity risk.
I've got a service that I love. We use a company online called KnowBe4 with the number 4, and we use it religiously, and that's exactly what it teaches. And we have new classes every month. You can do it every week. It's pretty good and very cost effective.
To be clear, under these provisions, the employer is not charged correctly. I'm not really sure what that means. But if you're saying that, are you penalized if you're not following if you're not following the rules, the Department of Labor, of course, can penalize you. So I think I am confused with this and unemployment. When would sick leave apply versus unemployment if an employee cannot work because they tested positive? Well, if an employee tested positive and he or she cannot work, you first trigger the Epsilon, right? And unemployment is something very different. Unemployment is meaning they're no longer employed. So if they're unemployed because of either resignation or termination, then obviously the unemployment benefits would trigger. But if you're talking about just purely applying sick leave because the employee cannot work because they tested positive for COVID-19, then that has to go under the Epsilon bucket. And if they've exhausted that 80 hours of paid sick time, then the question then becomes, are they able to continue remaining an employee? And again, it depends on the situation. So you always trigger the Epsilon bucket of 80 hours first if they can't work because they test positive for COVID-19. But as it relates to unemployment, then that's an unemployment issue. It has nothing to do with sick leave itself. Also, I've read in several places that healthcare providers are exempt from FFCRA requirements. Can you clarify? I think I already did. Healthcare providers are indeed exempt as long as you fit the need. But because of the August 3rd situation, they specifically gave direction to assess the situation on a case-by-case scenario. I believe we need another webinar specifically related to this topic, FFCRA, and much slower pace. It's just complicated and confusing, especially for everyone like me, that I don't deal with this on a regular basis. What do you think? I mean, I think that you're right. It is a complicated area of the law. It is something that requires a lot of attention, but just keep in mind, regardless of how much education you get, you're only going to benefit from it if it's tailored to you. So I know that everybody wants to raise their hand and ask, well, what about my situation? What about my situation? Well, my response is that you really need to seek professional help, whether it's through me or someone else. I think that it would really benefit you to actually go and take the time to seek professional help so that you can tailor these strategies according to your organization, because it's not a one-size-fits-all situation. Define status of employees account for the 500 full-time and part-time and contractors. The 500 count, full-time and part-time count absolutely counts towards the 500. The independent contractors do not count toward as you said, the 1099 does not count towards the 500. Regarding the leave requirements, are hospice organizations exempt? There is no specific hospice organization exemption for the leave. If our agency has way over 500 employees, this does not apply to us, correct? That's correct. The FFCRA only applies to 500 to employers that's under 500 employees. If they use all the 80 hours and do not qualify for the other 10 weeks, what happens if they file for unemployment on the company as a permanent layoff? Then that's what they can do. I mean, there's nothing preventing them from doing that. If they are unemployed, they're unemployed. So they have every right to do that. Of course, you have every right as the employer to contest it for whatever it's worth. And of course, when you get on the phone with the unemployment agent on the phone, you can try to explain the situation. But generally speaking, unless they resigned, there's nothing preventing the Texas Workforce Commission to issue the unemployment benefits. Must the employee request to be paid using the FFCRA paid sick time, or is the employer required to apply the paid sick time regardless? Yeah, that's a good question. So there's kind of an ambiguity. So generally they have to request it. But if the employer has knowledge of the employee utilizing the Epsilon time, and it's a situation where the employer should have known that Epsilon time is being triggered, then that places the onus on the employer as well. I'll give you a perfect scenario. If an employee tests positive for COVID-19, he or she doesn't show up to work. They never requested, hey, can I trigger my 80 hours? But they didn't show up because of COVID-19. At that point, as the employer, you should know that that's the bucket of time that should be triggered because they can't show up for work because of COVID-19. So hopefully that answers your question. Does the leave include employees who are doing virtual school due to COVID? Okay, I'm sorry. Does the leave include employees who are doing virtual school due to COVID-19? The school is open, but the district is only offering virtual classes. Because schools are still open, that scenario is interesting because I've heard it both ways, in the sense that because the school is open, technically school is available, but because of the lack of care that you provide at home, I think that's enough to trigger the leave to address the education, because the actual school itself, although being in session, it doesn't allow the child to be removed from the home, thereby still being at home, so thereby you still need to care for the child. Our agency is both home health and PAS. Our PAS has 600 plus employees alone, but they are not full-time employees. Do we need to establish FTA calculation? for those PAS employees. The calculation is that if it's an employee, it's an employee. It doesn't. It does count towards the 500. Did they identify an alternative definition though, or does it then have to be rewritten? I'm not really sure what alternative definition you're alluding to, so I can't answer that one. Amy, will the slides be available to us after this? Amy, you can answer that. I suspect the answer is yes.
Yeah, we'll send out that email that has the slides and the recording.
Okay, so we shouldn't be concerned then, because presumably all of us are here are healthcare. Again, I'll explain it one more time. It's you have to look at it on a case-by-case scenario. You specifically have to look at who's requesting a leave, and if it's a healthcare worker, that could be treated very differently than, say, your accounting person. So you have to look at it on a case-by-case scenario, and this is specifically because of the August 3rd decision in federal courts. So it's not we can just presume one thing or another. You have to look at the situation. You have to look at their job roles. You have to look to see what they're doing. Are they responding in any clinical fashion? Did you already previously allow certain leave and before? Because if you already started down that path, then you have to continue down that path, because you chose to, because it does allow you to allow healthcare provider employers to elect to allow for the leave. And you also have to balance that out with how that's going to provide additional exposure to other situations, because if an employee is readily exposed to COVID-19 or the risk of COVID-19, that could impact your decision on whether or not he or she should be granted the leave. I can confirm employers' accounts are not being charged by TWC for COVID-19 related unemployment claims. Okay, great. So if an employer that has more than 500 employees and choices to pay the COVID-19 sick and medical leave take the tax credits, I think that's an Amy question. I was told that they do not get the tax credit because they are not required to provide the leave. Only employers under 500 employees can take it credit. Can you clarify, please? That's an Amy question. That is not, that's a accounting question.
That is true. It's only eligible for employers under 500 to get that credit. And that looks like the last question that we have right now.
Yep.
All right, Charity, you want to say hi? We missed you in the beginning and we were a little bit sloppy and messy, so I'm going to let you close this out. Oh, maybe not. She's not. I don't know if she's not on the call. Okay.
Amy, are you there?
Yeah.
Amy, sorry, I had a little mute issue. So yes, thanks, Amy. I was a few minutes late getting on. Everyone, I'm Charity with Healthcare Consult Link, and I just wanted to say thank you very much for joining. And I did want to correct one thing that I realized was incorrect on this slide that's showing right now. Session 7, where we'll talk about the psychosocial impacts and growing your agency operations, is listed as being on August 6th, which of course is today. That is a typo. That will be next Thursday. And so if you want to go to the webinar series webpage that's at the bottom of the page, you'll see the registration link for both the bonus session as well as session 7 and session 8. And the slides for today are already posted there. So if you want those, they are available already, and you can go and open the PDF and print it or save it to your computer, however you'd like to do that. So thanks, Amy.
Okay. And just about my bonus session next week, it's on Tuesday around lunchtime. And I plan to literally teach you how to do the forgiveness application for the PPP loan on only on the easy form. I can't get into the big, long, complicated one, but the easy form I can go through step by step. So that's what we intend to do there for those of you who are ready to apply and banks are accepting. So look forward to seeing everybody next week, and we'll sign out from here, and we'll have the recording posted by tomorrow morning. Thanks, everybody. Thanks, Richard.
Thank you, everybody.